has so many so many provisions. The Secretary has tremendous discretion in terms of who's being regulated, who's not being regulated. All the suppliers in the industry will be regulated. All of the consumer plans will be regulated by the government. You may not have to buy them, but that's what the only ones that will be there. And there's a privacy issue, which is that you're probably going to have to be willing to provide your personal medical history to the federal government.
Right.
And where are you doing on that?
I appreciate that. The individual mandate is what has the greatest, legally, the greatest chance of being thrown out. The Congress, many of those provisions are going to have to be ones that Congress is going to have to pull the money on. Now, the problem with pulling the money is that Obama and his administration, I've understood, is already saying, hey, that's fine, because we have this pool of money for stimulus that we haven't spent yet. We'll just stick it over here and use it for health care, which I think is irresponsible and, But in the long term, you can't just simply take money from that pool forever. It's going to dry up very quickly. So,
what about the privacy pieces?
Yeah, and I think there's some serious concern regarding the privacy issues. I think those are going to have to. We're going to see how it plays out with regards to this litigation. The reason is this: it's still undetermined whether or not the healthcare law, if you want to say bill, but the law will only be partially removed or in total removed. And the reason is this: first, we went through every line, our attorneys, every single line of that law. Okay, 2,000 pages. Okay, and we found at no place is there a severability clause. Meaning, usually, whenever you have any law at all, every single law always has a severability clause, which basically says, if any provisions of this statute are declared invalid or unconstitutional, the rest of remaining will remain in effect and continue on. Every basic rookie drafting legislation always puts in a severability clause. They were so incompetent in how they rushed this thing through, they didn't put in a severability clause. So, that it's not a guarantee, because we have some judges say, and even in the Virginia case, say, hey, you know what? We're not sure. It's still undetermined what else would be invalidated. All I can say is right now, individual mandate, unconstitutional, and I'll leave it up to the Supreme Court to decide whether the whole thing gets cut out or just this part of it. And so that's still open that's still an open question. And also an open question is to what extent the House is going to try to rein in some of those provisions. And I think that the more immediate should be the more immediate focus is on the House to specifically rein in some of those other provisions that deal with privacy. It's very disconcerting, and I just don't trust the federal government. So, does that sound strange? No, it doesn't. Thank you, sir. I'm glad you mentioned that, because there are some other points to it other than the initial mandate that have to be addressed. Yes.
Yes, my name is Michael. In 2008, the local family court has taken my 10.5-year-old away. I have not been able to talk to her even on the phone. Anyway, they have used this thing that you may have heard about. It's called parental alienation syndrome. When they can't find anything wrong with you, they just pull it out of thin air to accuse you of something that they can't prove, they don't have to prove, and so on. To make it even worse, I did a little research. The people have done this thing, the so-called mental health professionals who are ruling these family courts. They're all not just members of the SEIU, but they're stewards of it. So I ended up searching it. That was Bill AB 612 in the state legislature. So I'd like you to comment on that, and then I would like you to touch on, because I know it didn't pass. I would like to know why it didn't pass. And then I would like to know what we can do to elect family court judges that will be able to stop this kind of.
Good questions. Very good question. And my heart goes out to you, by the way, because I didn't talk about what we do with regard to CPS. First, we at the Civic Justice Institute. I've been in juvenile court. I've actually had cases where I've defended parents who had their children wrongfully being taken from them, or wrongfully being denied grandparents. Instead of giving to the grandparents, they said, no, we want to go with this progressive couple. I'll leave it at that. And I've been to the court and almost got sanctioned at one time because I said, Your Honor, there's no evidence against the grandparents. And they said, well, I trust CPS. I said, Your Honor, it's not a matter of you trusting CPS, it's California law. She says, look, I will tell you what I will do. And if I believe this is wrong, that these are the right couple, then I can rule that. I says, Your Honor, I'm just asking you to abide by the laws of the state of California. And with that, she started screaming and yelling at me for no good reason. Okay, anyway. And then she suddenly stopped, and after she just totally went off the... And I thought, okay, here comes my sanctioning. She's going to sanction me for 2 weeks behind bars or something. Because I was out of line. I mean, I was really... when you have little kids, though, being put where she was going to put them, you'd be screaming too. So, contesting it. But anyway, she stopped and she said, I'm going to have to recuse myself. I've obviously crossed the line. I hereby recuse myself. Boom. But another judge came in. Yes. And that judge goes to the attorneys for the other side and says, is it true you have no evidence against why these kids should be put with their grandparents? And she said yes. And they said, okay, by 3 p.m. today, I want those kids put with their grandparents. And that was a win. And then we had a mother who had her kid taken and did little infant not returned for 10 weeks, or 10 months, excuse me, 10 months. And now we just give emergency counsel. We can't take on these cases because we need reform. So what we do is we write emergency counsel to any parent who needs emergency counsel prior to the children being taken. And we're very successful prior to the children being taken. The second is we're pushing for state reform. We spent a year and a half drafting model legislation to get more protection for parents and children, because you protect both at the same time, really. But by giving greater due process protection, I talked to the ACLU, they said, oh, yeah, we're not for that kind of due process protection. Seriously, that was their quote, end quote. Yeah, shame on them. So we drafted that. A number of states are using our model legislation, legislators are, and in California we're encouraging it, and I'm not going to give our strategy of how we're doing it because I'm not sure who's here. So anyway, but there needs to be reform. And on your situation, we deal with all the time with CPS. They often have a thing. Again, they have a male bias, an anti-male bias, oftentimes, and so they're real quick to separate fathers. But I don't know your facts, so I can't really give you more than just that. So. I think that we will see, let me say this, we will see continued attempts for reform to give greater due process protection for parents. That is a given, and that is something we are strongly behind the scenes working on. You won't see press releases on it, but I guarantee you it's something we're very strongly behind.
And the last point was, I know this particular judge, which is a nice guy, but in the wrong direction, he was elected,
oh yeah, let me touch on that, the judges. The judges. A friend of mine, Craig Huey, you guys heard of Craig Huey? He's put together his last election, a judge voter guide on judges. And I was so happy that I met with him in December, and we had another meeting scheduled for tomorrow morning. It's been rescheduled, for both of our schedules purposes. But we're going to be meeting some more, but I'm very excited. I talked on the phone, I said, I'm really glad you're doing this, so we don't have to. How can I help you? How can I promote what you're doing and get it out? So I think a lot of it is just taking what he's preparing. He's done a great job with it, very sharp, and then using that to really help hold local judges accountable. I think it's a really important thing to do.
What is his name again?
His name is Craig Huey, H-U-E. Y, thank you, H-U-E-Y. I'm sorry, I went to a public school. I misspelled it. I shouldn't say that. I love that joke. I use it all the time. So, yes, go ahead.
A couple of local issues that.
Thank you, sir.
A couple of local issues that came on that I heard about recently that I'm not sure if you were involved with, but you never heard the real outcomes. A couple students or some students at Live Oak decided to wear flag shirts on Cinco de Mayo, and they were suspended. And I think somewhere in the East Bay, a little kid decided he was going to ride on his bicycle with a flag on it, and he was suspended. He was, I guess he was threatened with suspension and some motorcycle. I guess the Hell's Angels drove in with them.
Yeah, I saw that.
What happened to those administrators? What happened to those administrators?
Yeah, let me just say. Well, I saw that on the news, and I quickly picked up my phone. And I said, I want to help this kid. By the time we looked into it and everything, the administration completely backed down on it from what we heard, and there was no continuing real case or rivalry at that point. But we at Pacific Justice have been very